very much. I'll be sharing time with my colleague. This will be seconded by my colleague, Senator Bajic. I'm pleased to welcome Minister Keogh here this afternoon, and indeed officials from the Department of Jobs and representatives of the Mandate Trade Union, whose members will be directly affected by the area of policy that this bill intends to cover. I'm very pleased to have the opportunity to table this bill and to debate it here this evening. The Labour Party is proposing this bill in a context where the standard employment relationship is declining and atypical work is increasing. Non-standard terms and conditions can be imposed on the vulnerable, the low-paid, and those with very little social protection. And where these conditions become a fixed feature of the employment landscape, that's where we must sit up and take notice and act. Women, young people and migrant workers are overrepresented in non-standard employment sectors like retail, hospitality and the community care sector, sectors that are poorly paid, insecure and which encourage practices that are at the outside or at the very least on the extreme edge of our employment protection laws. We all accept that employment policy has to strike a fair balance between an enterprise's need for flexibility and the employee's need for a level of predictability in terms of one's working life. Section 18 of the Organisation of Working Time Act deals with workers who have a contract requiring them to make themselves available for work. The section sets out a floor of minimum pay entitlements of someone whose actual hours don't match up to his or her hours on call. But what the Act doesn't deal with is a contract with either very few or no guaranteed hours of work and no requirement, on paper at least, for employees to make themselves available outside of those guaranteed contractual hours. Many workers are now encountering new terms and conditions, the so-called if and when contract, under which employers are under no obligation at all to provide any work of any description. And this has become, frankly, an arrangement of choice for some large retailers, and indeed many employers in the hospitality and care sectors, to name but a couple. For example, a typical contract might say, and I quote, "The company is under no obligation to provide work to you at any time, and you're under no obligation to accept any work offered by the company at any time." So it seems to me that these if and when contracts aren't caught by Section 18 of the 1997 Act, and it may be that these workers are frankly outside our entire system of employment protection law. And this is because under this kind of arrangement there isn't any obligation whatsoever on the employer to provide work and no obligation on the worker to do any work that's offered. A court requires mutuality of obligations before it can establish whether or not a contract exists. So if there aren't any enduring mutual obligations, there may not be any enduring contract at all. So if so, then people working under arrangements like these are effectively being told that they are casual day workers. These are perverse arrangements, and they're aimed at downgrading the status of employment. Imposing these kinds of terms and conditions on the vulnerable, the low paid and those with little social protection is completely unacceptable to me, is completely unacceptable to my party, and I hope that government and members of this House would agree. Workers in these situations are put at risk of job insecurity. From the perspective of the enterprise, there is limited integration into the business, there's low motivation, low productivity, low job satisfaction, and entrapment in a succession of short-term, low-quality jobs with little or no social protection and little or no legal protection to speak of. And the social and economic consequences, of failing to act to provide a growing army of precarious workers in this country with greater protections, the basic level of certainty, predictability and income security is incalculable. In the end, if we preside over a situation that allows the status quo to continue, nobody wins if this situation continues to exist. I want to now go on to describe some important provisions of the bill in more detail. Section 4 amends Section 18 of the Working Time Act of 1997. And the purpose of that section was to provide a minimum entitlement to payment for employees who are contractually required to make themselves available for work, even when no work is in fact provided. And the section is stated to apply where a contract requires employees to make themselves available to work in a week a certain number of hours, or as and when the employer requires them to do so, or both a certain number of hours and as and when the employer requires them to do so. However, Section 18 then states that a requirement to be available is not held to arise by virtue only of the fact that the employer engaged the employee to do work of a casual nature previously, regardless of the number of previous occasions and of any circumstances that would give rise to a reasonable expectation of further work. So the amendment that we're proposing in this legislation to Section 18 of the bill deletes this qualification so that the section can in future apply to and protect, importantly, employees who are initially engaged to do work of a casual nature. Section 5 amends the Protection of Employment Fixed Term Work Act 2003, and that Act confers entitlements of fixed term employees who have completed their third year of continuous employment with an employer. It can be hard for an employee to prove continuous employment, so Section 5 introduces two important and consistent new rules to assist them, dealing in the first instance with continuity of service and also the use of PAYE information held by the Revenue Commissioners to determine the reality of the contracted working arrangement with the employer. This is an important new innovation. Section 6 of the bill deals with continuity of employment for employees who may otherwise be deemed casual, and Section 7 concerns provision for a corrected written statement of hours of work. An employee who has benefited from these provisions will be entitled to request the employer in writing to correct the employment contract so that particulars of the weekly hours of work reflect the pattern of work actually done per week in the previous 6 months. An employer may refuse to do so if there was a particular pattern or system to the hours of the previous 6 months that was due to the seasonal nature of the work or to an emergency or other exceptional circumstances. Section 8 of the bill includes an important anti-victimisation provision which states that an employer shall not penalise or threaten penalisation of an employee for invoking rights or procedures under this bill, and that particular section is very similar to a section we included in the Industrial Relations Amendment Act of 2015 around collective bargaining. Sections 9 and 10 provides for complaints to adjudication officers of the Workplace Relations Commission. Section 11 invalidates any provision in an agreement, whether a contract of employment or not, and whether made before or after the passing of this Act, that purports to exclude or limit the application of or is inconsistent with any provision of this bill. However, and this is an important point to make, Minister, the bill allows for a registered employment agreement or a sexual employment or an employment regulation order, or indeed a sexual employment order provided for under the 2015 Act, to provide the provisions of the bill don't apply in relation to the employees to whom the agreement or order has effect, or to a specified class of those employees. So in other words, there are alternatives, and we are always seeking to encourage trade unions and employers to engage under the provisions of the 2015 Act to ensure that they can use that Act to create better terms and conditions, better sectoral terms and conditions, and better enterprise level conditions by way of registered employment agreements and sectoral employment orders, because there is no substitute in the workplace for collective bargaining and all that that involves in terms of improving the living standards of employees and giving certainty to the enterprise for entrepreneurs and for business owners. I want to remind the Minister, in conclusion, that the programme for government commits to addressing growing casualisation in the Irish workforce. And on that basis, I am hopeful that government can and will support this legislation. I think this legislation can and will prove to have a transformational effect on the lives of working people in this country, particularly for those who are caught in perverse, if and when, contract arrangements that are, as I said earlier on in my contribution, outside of or at the very edge of the current suite of employment legislation and regulations that we have in this country. And I think it is high time that we address this issue and that our employment laws and regulations finally catch up with these phenomena that would not have been anticipated, for example, when Section 18 of the Working Time Act of 1997 was drafted by one of my predecessors, the then Minister of State, Edna Fitzgerald, nobody could have anticipated the way the world of work evolved and how these phenomena would develop in subsequent years. And it's important to point out, I think, as well, Cathaoirleach, that where these type of phenomena catch hold, people become disconnected and alienated from society. We don't ever want to see large cohorts of workers, people who work extremely hard to provide for their families, being disengaged from the enterprise they work for and disconnected from society because dignity for them in the workplace is not respected and they do not feel that they have the respect that their work entitles them to. A basic certain level of predictability in the workforce surely should not be something that would be beyond us in this country, and I think all of us in this House would accept that the status quo should not prevail and that it is high time that changes were made to Irish legislation to take account of the problems experienced by those in contracts. Thank you, Cathaoirleach.